I apologize here for being a couple minutes late. So I will try to get right started so that we can avoid taking up too much time of folks' nights. We certainly appreciate everybody that's making the time to be here with us. And so I won't cover anything too important here in the first few minutes as we kind of make sure that everybody who wants to be in here is in here. Um, but uh, but I will get started here just kind of from the get-go. So let me start by introducing myself. My name is George Paget. I am an attorney with Seaver Walker Paget. We are a law firm that does eminent domain work just for landowners. We originally started our practice with sort of I guess you could call it a Midwestern geographic zone, but since we've been doing this now for 15 plus years and we've gotten very good at it, we started expanding, a while ago into more locations. And we are, as a firm, particularly track on these type of energy related projects wherever they are. And of course, those are not always in the same locations. And so we go where there's a need for us, typically in those cases. So that is why we are here today to talk to you about these pipelines in Mississippi. What I'm going to do is I'm going to basically try to keep this to about 30, maybe 40 minutes max, again, to be respectful of people's time and make sure that we're not taking too much of that. I have a PowerPoint presentation that I'm going to work my way through, and that'll be the majority of the webinar tonight. With that being said, that will be mostly a lot of me talking, but there will be plenty of opportunity for folks if there are questions to either use down at the bottom of, at least at my screen, I assume it's the bottom of yours as well. There's a toolbar that has some different options. And so one of the options is to either chat or I think there's a Q&A option. So folks can use those to ask questions as we go. I may not see it immediately, but I will probably see it within a fairly reasonable amount of time. And then I will do my best to answer those questions as we move through the information. If it feels like we're getting too many questions and not able to get through the information quickly enough, or if I feel like the questions, any of these specific questions that I get are better suited for a different conversation, more of a one-on-one conversation, I'll just let folks know that. And then, if there's still a desire to have that question answered, we can schedule, you can send me an email, we can schedule a time to get together on the phone and to talk about that, or I can potentially even answer it over email. So with all of that being said, I'm going to get started here. I'm going to give me a second here while I start the process of sharing my screen, and then we will go through the presentation that I've got prepared. All right. So, basic info here for me and for our firm. If anyone wants to jot this contact information down, feel free. Uh, Again, Seaver Walker Paget Law Firm. We've got a phone number for the firm. We've got my direct number, the 614 number below that. Also my email, george@swp-legal.com. Either any of those virtually are a perfectly fine way to get in touch with me if there are questions or more conversations that folks are desiring to have after the webinar or in the future. So who are we and what are we doing? I did tell you we're an eminent domain law firm that works with landowners. Just to kind of give you a bit more clarification on that, we are landowner only. So we do not work with any condemners, much less pipelines, but we're not with the pipelines. We are a private law firm, and our sort of business mission is to assist landowners who are affected by eminent domain through the eminent domain process, right? So our goal is to help folks receive both fair compensation and fair treatment. And when I say treatment, what I mean is there's documents, easement documents and side letter agreements, and there are potentially additional things that folks would need someone to help them through with the process. We want to make sure that the folks are getting the other side of the story, so to speak, and not just being told, here's how things need to work by the pipeline, and being put in a position where, they don't have the ability to sort of question or understand, how things should be working. So that's essentially what we're here to do. We've done a lot of pipeline work. As I mentioned earlier, we've sort of made that one of the focuses of our practice over time. There's a lot of infrastructure like this that gets put in all over the country, and there are frequently not necessarily folks in those locations that are doing a great deal of that work. And so it's, from our perspective, helpful for us to be available to these folks as a resource, a source of information first and foremost. But then also, if there's a desire from everyone, ourselves, the landowners, we'll then obviously work with folks as well to actually represent them, help them through the process. So tonight we're going to discuss a little bit about the project. I'm not going to spend very the projects. I'm not going to spend very much time on that. Truthfully, that's not really why I'm here. There's that information's kind of all out there available on the internet if you want to know where the project starts, where it ends, and all that good stuff. And then I'll also talk about, eminent domain and some things to look out for, some things to expect, hopefully give you some information that'll help you be a little bit better prepared for what is to come when you get involved with this process. So a little bit about the projects. They're across Mississippi. I'm going to tell you folks the truth. I got the wrong picture on here, so ignore the picture. But the projects are governed by FERC. FERC is the Federal Energy Regulatory Commission, which is a federal agency whose sort of purpose is to oversee the application process and approval process of these types of pipelines. And so both of these projects are currently in the FERC process. That is a process that takes quite a bit of time to play out. So I wouldn't expect either of these to be approved, next week or anything like that. I think we're talking about months in terms of timeline for them with FERC. But that is only part of the puzzle. That doesn't really mean that everyone's timelines are on that type of place or that anyone has to do anything immediately, although, we certainly recommend being proactive about these things. And ultimately, the FERC approval, if these pipelines do get approved by FERC, that is when you're technically talking about them having eminent domain authority, and that eminent domain authority being something that could be used against landowners that are not able to that they are not able to willingly reach agreements with. And so eminent domain, that's kind of the boogeyman word. That's the thing that folks are afraid of, which is, I think, understandable. It is not, though, something that you have to be that afraid of if you understand what it is, understand, like I alluded to before, the things to look out for, the things to consider. Basically, if you're educated, you've got someone that you're working with in some capacity that can help you through the process, you're typically not something you need to be too terrified of. So let's talk about, eminent domain and what that really looks like. So eminent domain is technically the power to seize private land for a public use. So this is a power that the government has. It is in the United States Constitution in the Fifth Amendment. It is also typically in every state constitution memorialized explicitly somewhere. It's also got common law roots. It is something that has been around for a long, long time. Obviously, over time, the way it's been used, the way that we see it today, it's evolved. But effectively, you're talking about the government taking your property for a public use. And so roads are the most common example. We're talking about pipeline infrastructure here. It may not seem, I'll say real quickly as a PSA, because this is something that I talk to folks a lot about. It may not seem that them having the ability to take land from you so that they can pump natural gas or whatever it is that they're pumping, across the country to someone else. It may not seem like that is a valid, public use or a valid use for your property specifically. But I think the rationale that is most commonly used and I think fits this situation the best is that we need this kind of infrastructure. We need energy. We need the ability to get energy where it needs to be so people can heat their homes and do the things that they need to do. So even though this is technically a private company, they are given the right of eminent domain by the government. They become a governmental authority, basically, in this specific instance, to use eminent domain to acquire the rights that they need, that they can't acquire voluntarily. So the flip side of that power that they have is that you are always entitled to just compensation. So this is not always going to make everyone feel like this is a fair process. I think I would be remiss to sit here and tell you this is going to be or is always a fair process. There's definitely a significant difference in the power here. It tends to be on the other side of these things, but there are things that we can do to help try to balance that and to help put landowners in a more advantageous position than they would be in otherwise. And so that's a big part of what we're going to talk about here. When we say just compensation, technically what we mean is you should theoretically, from a money standpoint, a value standpoint, be as good, as well off as you were before after this is done. So they come and they say, I need 5 acres of easement, and they say that that's worth X dollars. Ideally, whatever you receive, whether that's X, Y, or Z, will be representative of the true amount of value that there is and what they've taken from you. So therefore, you would be effectively in an equal position when the process is done. So that's certainly the way that we hope it works. I think that if I'm being honest, again, there are lots of different types of outcomes here that can be good. And then certainly some folks receive bad outcomes. It certainly depends on the way you handle the process. So just compensation is a little bit of a moving target, but it is the goal. So what does the whole process look like? There is typically before condemnation going to be an offer made, and that's where you're going to be talking about the right-of-way acquisition folks, probably a third-party company. I know from what I've been able to gather, there are certain folks here who have received an offer, and then certain folks here who have not. So there's going to be people with different experiences thus far. But those right-of-way people, that right-of-way agent, that's the pre-condemnation part of this process. They'll make you an offer at some point if they have not already. This is typically where a firm like ours gets involved, right? You have the opportunity if you do the right things to potentially negotiate a perfectly good, if not great in some cases, deal from this pre-condemnation phase. But there's a lot of pitfalls. It's not the easiest thing in the world, and I don't just say that because it's self-serving. I want to be transparent. I truly do. We truly do believe that. And so, you have that opportunity, but you want to make sure that you handle it the correct way. If that negotiation, and this is true of basically no matter how you get there, if that negotiation period, if that pre-condemnation period is unsuccessful, you end up in a condemnation lawsuit. Now, the main caveat that you'll see there in those parentheses is that that can't happen until they've got FERC approval. So we're not going to see condemnation lawsuits, in the next few weeks. Again, we're talking months in terms of timelines before any of that's even possible, I think, at this point. But it is the next step. It's likely that those would be in federal court because with FERC being a federal agency, there is sort of federal jurisdiction over a project like this. They could choose to bring that lawsuit in the local county where the property is located, but you will not know that until that happens. So, assuming that it is in federal court, your ultimate backstop is a trial on compensation where each side gets to present evidence about what this is worth, and ultimately a jury is going to decide what it is worth. And so in federal court, though, there is no guarantee of a jury trial. That's a very important caveat to what I've been explaining. In state court, you typically are going to have a guarantee of a jury trial. That's a big part of why we say federal court is likely, because that's certainly advantageous, I think, to the pipeline more so than it would be advantageous to the average landowner to have no jury. So that condenses a very long process into a very simple few bullet points. But that's generally how this goes. Pre-condemnation offer some time to hopefully try to figure things out if possible. If you can't, you end up in condemnation. That typically is in the form of a lawsuit. That litigation is what I would call pretty typical litigation. It's not particularly special, but there are, of course, special rules and deadlines and different things that folks need to be aware of. And ultimately, you've got that trial backstop. I'm going to jump out of full screen here to see. Okay, it doesn't look like we have any questions, so let's go back in. Um, what are they wanting from you? What really is happening here? Um, Ultimately, what they're looking for is an easement. Now, I don't want to assume anybody here doesn't know what that is, but I've certainly talked to enough folks to know that there's not always an entirely clear picture in everyone's head of what an easement is. So I'll start with what is this thing that we're talking about? It's basically, I mean, it is in a sense a deed that you are granting to another person or entity, but the big distinction between this and like a typical you sell your home to the next person who wants to live there type of deed is that this easement does not transfer 100% of the rights. First and foremost, it does not transfer ownership. It is essentially a transfer of rights to a certain portion of your property. And that easement document then will outline what can they do there and what can you do there. And that includes also, of course, like what they cannot do there in certain instances and definitely what you cannot do there. So that easement document and any other, if there's a side letter agreement or any other elements of the agreement in total, will dictate what happens in that space from basically now until forever. Because these types of easements are granted typically in perpetuity, which means that there isn't going to be a renewal period. There's not going to be a time when you get to come back and renegotiate this. So there's a fair bit of importance that we try to place on making sure that that easement is negotiated in a way that puts landowners in a decent position. We don't want folks to, and I've heard these stories, to be a few years down the road, things are a total disaster. They signed an easement that it was really advantageous for the pipeline company, and they're having trouble getting anything accomplished as it relates to, repairing their property, restoring it, damages, all that good stuff. So there's a lot that we try to do with the easement to make that better for the landowner. Um, Now, the last part right before pitfalls, where it says what is told to you is not always what the easement says. I think that's particularly important. These right-of-way agents, they might not have specific intentions to trick anyone, but there is certainly some hiding of the ball that goes on in this world. So do not take anyone's word for what the easement says. It's really important that you have somebody that you can put that easement in front of and have them tell you what it says. And you, someone with experience in this world, a lawyer, that would be, really ideal. It's possible that you could find someone else who's got a lot of experience dealing with easements, but you really want to make sure that you understand what that says, because what you think it says could be not what it says, which is just another way of that just underlines what I was speaking about earlier, which is the importance of making sure that that easement is cleaned up and negotiated appropriately for landowners, so that there aren't going to be a bunch of regrets down the line. This pitfall section, not all of this is going to apply to every single possible person or easement, but there are a lot of things that you can, landmines that we can run into when we're talking about this, and particularly that landowners can run into. Unfettered access, you want to make sure that there's not, as part of the agreement, their ability to do whatever they want, wherever they want. And that kind of goes along with access to the entire parcel and not just the easement area. You really have to make sure that you have clauses in there about damages and restoration, which I had just hit on a few minutes ago, so I won't talk about again. But those are really important. They will govern what happens if there's a problem in the future. Those are probably two of the most likely problems to occur. So you really want to make sure that you're addressing those. Liability is a big one. There are general common law rules for liability that do typically cover these kind of situations, but there is no better place to be than to have, explicit language that says this is how this will be handled. This is not the landowner's responsibility kind of thing if these problems occur. And then the last one is probably the most important. Not every easement that we see tries to sneak this in, but you occasionally will see easements where they try to sneak in the ability to grant rights to third parties. If they could allow someone to put a transmission line over the pipeline, they could allow another company to come in and put a pipeline next to theirs. Talk about they could be sort of uh, hiding the ball in an attempt to have their own right to build more pipelines rather than one. You see solar farms, different things. So really, all of that boils down to making sure that third-party access to the easement is limited, if not non-existent. So that what you've done is you've only granted certain rights to this certain company, and all that anyone's ever going to have are the rights that you granted within that document. So those are some things to keep in mind as you're thinking about an easement and what it might mean and what some of the things you might want to be thinking about. Uh, what a complete compensation package should include. So we talked about the easement. Now let's talk about the other half of this really, which is money. What is this worth? What should you be receiving in terms of compensation because of this easement? So there's a few different things. You can make this as small or as large scale. You can have this conversation either way. The 30,000 foot view is you're entitled to compensation for the dirt that they're occupying, the acreage that their easement will cover, and then you're entitled to compensation for any damages that the uh, easement will cause to the remainder property. And in this case, since it's just an easement, the remainder property is technically the entire parcel. But you could also think of this as any damage it will do to the space outside of the easement, but still on that same parcel. So that's the big picture. If you want, but you'll see here, there's some, more minute or more specific examples that are important. So we talk about price per, acre, value of the land encumbered. But then you're going to have things like potentially crop damages, timber damages. Um, there's typically, uh, no matter how well intentioned we all are, and no matter how well the easement is written, there are almost always going to be issues with your dirt not being exactly like it was before. If we're talking about farm ground, you're going to potentially have to spend time and make investment in restoring that soil when all is done. And this is even after we've made them, or we've written into the agreement that they'll segregate topsoil and that they will stockpile separately and that they will replace. And we do all of these things, but nobody is perfect. And so these payment for anticipated soil and ground damages or a clause in the easement that guarantees remediation, that's another important point. There are all kinds of other things. I mean, not everybody tiles their fields all over the country. Not everyone has irrigation all over the country, but some of these other things like compaction, soil mixing, debris, standing water from compaction, those issues are going to potentially exist anywhere. So either again, a plan for those things or some type of compensation to cover their eventuality. And then residual damages, that's what I talked about initially in terms of any damage to what's left, the property as a whole. And so I think something that I like to sort of offer in terms of context here, we try in certain circumstances, we try to, if we can, be paid for specific things. But ultimately, we kind of call it like the haunted house theory. There is this idea that this is going to cause problems, and we might not know exactly what the problems are. We might not know whether they're going to be health-based or whether they're going to be danger or whether they're going to be aesthetic or whether they're going to be, you know, um, any of these other things we've already talked about. But once you have this easement, then you have something different than what you had before, which was a property that presumably did not have a high pressure gas pipeline easement on it. And so, when we talk about damages, it can be that simple too. Just the idea that this is not the same and therefore at least presumptively inferior to what existed before, and that is justification for damages. Obviously it's a little bit that's way more nebulous, and being more specific can sort of help you get over some of those hurdles at times. But it is also an equally valid way to couch the issue, in my opinion. And then all of that is in addition to, sometimes in these kind of situations, there are payments that we've negotiated that are not even necessarily tied directly to anything, but just additional payments to get the deal across the line, or sometimes they will offer those things. So any and all of those things, and potentially some others, could be part of a compensation package. Uh, and so they're all worth considering, and good for people to have, on their radar screen. Let's talk about right-of-way agents for just a bit. Um, we've seen a lot when it comes to these folks and how they do what they do. Um, there are, again, I'm not casting aspersions. I'm not saying anyone has any specific negative intentions, but they will do things that are sort of meant to reframe the issues, and convince landowners that things are really much better than they are. They'll do things like, well, we've gone and determined the fair market value and we're giving you 125% of that. Like that is some extremely generous thing for them to do. You'll see, what does that even mean? And who determined that? And how are we sure that that's correct, right? Um, you'll see bonus payments, timber and crop damages, they'll offer these things like they are the panacea. They are all you need for this to be great. But that is not necessarily true, and frequently not true. So we found that really the value from a landowner perspective is in leverage. Like you cannot underestimate the leverage that you have as being something that they need. You should not underestimate the amount of leverage you can create with a group by pooling resources and pooling, and joining together, banding together. Um, they will make verbal offers, and then you won't be able to get them to own up to that later. You might see one right-of-way agent for a few weeks and then see another for a few weeks, so that next right-of-way agent can just say, I don't know what Jim told you, but here's the deal now. Again, always kind of moving the goalposts on you. Ultimately, a big part of what we're here for, if for nothing else, is anyone can come to us at any time and say, what do you think about this? And we will always review your situation, your offer for free, and give you an honest opinion about whether we think we can help. So if you're not sure about anything, bring it to us. Bring it to somebody like us. If you've got another lawyer that you feel is competent, bring that to somebody who knows, will tell you the truth. We've got no interest in working with folks we can't help, and we've got no interest in working with folks that we're going to be risking. You've got such a good offer that we'd be risking you coming, leaving with less. And we're not going to take that risk. We'll tell you if that's the case. We'll also tell you if the offer is really bad, which is frequently what we experience. So, uh, ultimately, we're happy to take a look at that uh, and make sure that we're giving you good information. It looks like I do have one question here, and it essentially is the compensation going to be a one-time payment or an annual payment for use of property? What I can tell you is that typically the compensation um, agreement is a one-time payment. That is because the law, as currently written, only requires it to be a one-time payment. If it is going to be more than that, that is going to be purely of the volition. It'll be of the pipeline's volition. They might say, this is the way we want to do it, and that's great, but that is really uncommon. I think the expectation for everyone should be that it's going to be a one-time payment, which is a big part of what makes doing things the right way and hopefully achieving the right results, important, because we want to make sure, if you've only got this one chance to receive what you should be receiving, we want to make sure that is a fair price and it's as effectively as much as it possibly can be. So what to do when you receive an offer? We've, this is advice. Obviously, we're not telling a bunch of other adults exactly what to do. You guys can make decisions for yourself ultimately if you feel like you want to go another route. But this is what we feel is the best way in the early stages to handle things. Uh, Can you get your communications in writing? That is going to be valuable to you. So that is why we say insist that you're typically communicating via email. Once you've received an offer, do not fall into the trap of sitting down at the kitchen table and talking about how great it is or this or that. Uh, you know, Thank you. We're gonna consider this over some time and we'll get back to you. Again, we will review anything for free. So there's really a zero risk, zero obligation having us take a look at this, or again, if you've got someone else you want to have take a look at it that's got some experience in this world, do that. And as much as you can, avoid again the dinner table chats. And ultimately, that's not because there's guaranteed to be a negative outcome from that, but it is very unlikely to lead to a great deal of positive outcome for you. It is there's I that's that is a risk benefit analysis that from our perspective, as we've seen just in so many instances, it doesn't tip in your favor. The right-of-way agent, their job is to get you to sign on the dotted line. Your job should be to make sure that you do this the right way and maximize what you can receive. And that is not going to be done by having in-person discussions and being misled and those kind of things. So those are some things we recommend doing with the process. Sorry that I keep having to come out of here. I'm having some technical difficulties, but we're plowing through. What not to do when you receive an offer. And then some of this is duplicative, so I won't spend a lot of time here, but don't immediately sit down and talk about the offer and how great it is and how if it was just a little bit more, you'd be happy because you might have no idea that you could or should be receiving way, way more than you're thinking about at that moment. Um, this one's kind of important. Don't immediately go hire your own appraiser. Again, we're not telling folks what to do, but you are likely not using your own resources in the best way if you do that. You might need an appraisal eventually, but getting it immediately is not going to benefit you. And it's not going to, in a lot of instances, folks are not going to find the right appraiser that's going to have the right credentials and be able to deliver the right opinion. And all of that's very important as you move through the process. Don't assume the things that they're saying are true. I hit on that earlier. Don't assume that these are the good guys and that they're here to tell you the truth and that you can't do anything about any of this. Those are bad assumptions. You can do a lot about this. You can make your situation way better, and you do not have to take them or anything that they say at face value. And this last one might be the most important, honestly. There's no reason to like rush into making a deal with the pipeline. Frankly, a lot of the times that we've had the most success, that has taken time. There are sweet spots that you can hit in these negotiations and in these processes, the process that can lead to really, really good results. So you do not need to let them make you feel like this is something that has to be sorted out while they're standing there with you. So those are some do nots. I think I just got another question, so I'm going to pop out so I can take a look at these. Okay, so one is just not clear on how the pipeline company will contact us. So for those of you that haven't been contacted, what you'll typically see is you're either going to receive some certified mail, something that is going to, come with signature required for you to take a look at. But that is not how they like to do it. Again, they like to get you sat down at the table and talking. So a lot of times they will just sort of show up enough times until they catch you, and then they will give you physically your offer packet. So it's probably going to be one of those two ways. I'm not saying that's a guarantee, but I'm pretty, high level of confidence. It's probably going to be one of those two ways. And then I got another question. How do we factor in the value? Okay, so this is essentially asking like, I think I get this answer in this question in different forms at times, but how do we factor for the fact that this pipeline company is going to take this product and make millions and billions of dollars from it, and we're not going to be a part of that? What I can say, and it's not what I would love to be able to say ideally, but what I can say is that is just not how it works. I wish I could be a little bit more rosy than that, but again, the laws are written. I alluded to this earlier. The laws are written in such a way that they're required to make a one-time payment to you, and that payment is intended to be reflective of just how this relates to your property and its value. Now, that doesn't mean that there aren't, we've gotten people paid very handsomely for pipelines. It is a thing that we've been able to do many times in the past. But it's typically not ever tied to the value of what pumps through the pipeline or things like that. It's just not available to us. Um, you know, I don't know how any other better way to put it. If that's not a good enough answer, which it may not be, and I think that's fair, I am certainly happy to exchange some emails or get on the phone to talk about that a little bit more. But it's just one of those things you just don't get to share in the profits. The laws aren't written that way. They're not written by people who want to put you in that position, unfortunately. So, all right, I'm going to try to keep it moving because I'm approaching 40 minutes here. So, uh, FAQs, just these are things that we run into a lot. Do they have a right to survey my land? The short answer is yes. There is just a tag along right to survey for anyone that basically is even in the process of getting eminent domain. They don't have to get it to get that survey right. So surveying can be tricky. We're happy to field questions and talk to folks about that on a more personal basis if that's helpful. But they typically do have the right to survey. If you fight that, you can fight the good fight, but eventually you are going to lose that fight, and they're going to be granted by a court the right to survey. How do I find out if you've already got, like, if you're curious about easements and whether you have easements and different things, that's typically in your local county records that you'd be able to find those things. Some people know about it when they're buying their property. Other people don't notice those things always. And so, yeah, there might be, but that's something you've got to sort out. You got to go look at your local county records and figure out what you're seeing on your property. Um, how do you find out how much they want and where it will go? We typically don't know exactly the answer to any of those questions until they come to you and say, here is what we're doing and here is what we think it's worth. So, you know, that's just the reality of it. They do tend to try to be close to other easements. So if you do have other easements, you might see them be running in a similar pattern or path to those. We talked about how they'll give you the offer. What if I'm never home? How do they manage that? Like I said, they'll either be served on your priority mail or, I'm sorry, some kind of a signature required mail, or they'll just be that persistent. I mean, there's these people's jobs are to do this, so they'll just show up whenever they have to be able to catch you. And then this is super rare, but what if it goes through a building? I mean, that would mean that you would be entitled to compensation for that building. Although that's extremely rare, and I don't think something that you should expect to see happen. They typically do their best to avoid doing things like that, although they will sometimes be very close to improvements, which, is a damage consideration. So that's, if they're 5 feet from your front door, that's, you know, going to make your house worth a lot less, but it doesn't mean that they're going to actually take your home. You might still have to, it might still have to stay there, but we can hopefully get you paid for what the kind of damage that will do to your property. Um, when is the pipeline going to start and how long will it take? I don't have a super clear answer on that. I'm not even going to try to dance around that. I'm not, that's not information as I sit here today that I can give you for sure. Our general understanding, based on FERC process and their intention is for this to be happening in the next couple of years, probably talking about a 2020, like it'd be optimistic, I think, for 2026, but probably 2027 type of time frame. Typically, the whole project is going to take a long time, but the amount of time that they'll be on your property is typically not a huge amount of time. They'll be on there, they'll do what they got to do, and then they might have to come back to do restoration and things. So the process as a whole might span a couple months, but it's not going to be every day on your property for that entire period, grinding out work or anything like that. Again, if those answers aren't good enough, or if you're looking for more information, just let me know. Send me an email. I'm happy to try to help out a little bit more. But just in the interest of time, I want to keep it moving so we can get done here in the next few minutes. So let's talk about, you might be wondering, okay, this is all great. If we do want to work with you, how does that work and how do I make that work? We typically are working on a contingency fee, which means that you do not have to give us any money up front. We do not have to be paid along the way, but at the end of the process, when the dust settles, we take a portion of the value that we're able to add for you. So this example, you have a $10,000 offer, a $50,000 settlement, or it could be juried verdict. And then there's a $40,000 difference. We would get a third of that 40,000, which would end up, so you would end up effectively with almost $37,000, which is a great deal more than you started with. We're only taking a portion of that value we're adding. Why do we do it that way? Because it puts us in a position to have our goals aligned, to be, on the same page, and to be able to deliver results and not just work for the sake of working, right? I think a lot of times in an hourly fee agreement, not only can folks not necessarily afford that a lot of the time, it also doesn't really have the right incentive structure for this kind of situation. So this really aligns our interests, puts us on the same team, and kind of gets us where we need to go. Um, I think I just got one more question, so I'm going to pop out and take a look at that, and then try to wrap up. Um, well, so one of the questions is, can you show us where it's going in Mississippi? I don't have, we have maps. I can get you those. If you want to send me an email, I can probably get you a map that shows the proposed route on your property, or very, very close to it, a small, window of space. So that's something that if folks want to get more information on that, I can probably help you out, but I'm not going to have time to do that kind of thing today. And then the other question is, will we be responsible for future damage as it relates? I think this is generally environmentally. No, I mean, that's a big part of easement language. Like, this is not your pipeline. This is not your undertaking. You should not be responsible for those things. So we need to make sure as we negotiate this that the easement language puts you in a position where those are not your responsibilities. So that's certainly a goal, something that we strive to do, and in that specific sense, not something that we fail to do. We will make sure that it is not your responsibility to fix problems that occur in the future because of this, unless the big caveat is always unless you go out there and create those problems, which most folks are not going to do. So I don't want to pretend like anybody's going to go out there and dig up the pipeline and pickaxe a hole in it, and then act like they didn't do it. So assuming nothing along those lines, none of this should ever be your problem. And so that's an easement language thing, though. Okay. So what do we do from here? Again, when you receive that offer, you should be having someone take a look at it. You should be contacting someone like us and talking to them about that, and probably eventually finding someone to help you with the process. It's fair until then to be vetting your options, coming to things like this and getting more information. You also probably want to know what's important to you, right? If all you care about is money and the other stuff is no big deal, great. If it's the easement that you really care about and the money's just cherry on top, that's great too. If there's really specific issues that are very important to you, beginning to develop sort of those concerns and those ideas is valuable. One thing we've really had a lot of success with is building a group of landowners, like working with, let's say we're talking about 20, 30, 40 landowners on a specific project. And that just creates leverage, and it creates economies of scale, and it creates a need for the pipeline company to deal with that group in a real way. So there is value to that. And that's one of the things that, if I'm doing the selling of this process, or of us, that's one of the things that we do sell. I think we just had a lot of success with that. It's got a lot of value. So if you have any questions, or you have offers and you want someone to take a look at those, again, there's my email, um, phone numbers, fax number. So you can reach out, get a hold of us any of those ways. All of that is good. It doesn't really matter how you do it. Just do it if you're interested, and we'll find a way to work with you, and take a look at your stuff and tell you what we think. It looks like I did get one more question, so I'm going to try to answer that, and then I'm probably going to wrap up. Um, so this is a question back related to the compensation. And I think maybe there's some miscommunication here. So the 37,000 is reflective of the additional 10 plus 2/3 of the 40. So the third of the 40 is like 13, right? So, but that's 13 from the 50, because that you keep that original 10 no matter what. So maybe that math wasn't as clear as it could be. Maybe that's something for me to work on, adjust in the future. but no, you went from 10 to 50, and all we're taking is a third of the 40. So when you add the original 10 to the other two thirds, that's where the 37 comes from. So I try not to be too like it's you can't lose, but it is a minimally there's not much risk there because of the way that because of the way that that fee works. If it doesn't go great, then we don't get paid, much at all, and you didn't benefit a great deal either, but you also didn't end up losing a great deal from that type of situation. But what I can tell you is, I don't think anyone should have the expectation that if they work with us or someone like us on this type of situation, that you're going to end up losing. That it should not work that way, and I would not be here talking to you folks if we had any expectation that it would work that way. So, with that being said, I hope folks, will give us a call, shoot me an email, let me know if there's any way that I can help. I am going to wrap it up there so we can all get back to our lives, but I will be available by any of those other means of communication for anyone who's got more questions or just wants to get some more information, talk about their situation, whatever it is. So I really appreciate everybody coming out. I will hopefully be hearing from some of you and, helping folks with the process. But if this is the last time that we see you, then good luck, and we hope everybody ends up coming out of this in the best possible place that they can. So, good night, folks. I will hopefully we will talk to you guys soon.